Agency and real estate brokers. What we're going to talk about is what makes agency and what's the difference between being a broker or an agent in our marketplace. So we're going to define agency. We're going to distinguish among the different types of agents. We're going to distinguish among the various authorities of an agent. We'll talk about the difference between a broker and salesperson. We're going to talk about fiduciary duties. We'll identify available real estate agency relationships. We're going to recognize the different types of listing agreements. We're going to talk about a few of those. We're going to define when a broker is entitled to be paid. That's the whole reason we're in this business. And we talk about a broker, but when we talk about a broker being paid, we're also talking about the agent being paid. We're going to identify the duties owed to the parties. Real estate transaction, we're also going to explain federal laws governing our broker's activities. So it is a lot to go through. This chapter is going to take a little while to get through. Okay, agency. An agent is a person who represents another, a principal, in dealing with a third party. So we contract with a realtor to be our agent. We contract with a lawyer to be our agent, in essence, the lawyer relationship. But that's where we have these kind of relationships where people are doing our work for us or to help for us, help speak up for us, to negotiate for us. That's the fiduciary duty, and that's how agency is formed. The principal is the person who authorizes another to act on his or her behalf. So an agency relationship binds the principal in contracts with third parties and also protects the agent from personal liability to third parties. Unless they do something really stupid. I'm sorry, anybody that does something really stupid that's against the law, that's against the norm, is not going to be relieved of all liability. Just, you step the wrong way and you do it intentionally, I'm sorry, you're going to get in trouble. The law of agency governs fiduciary relationships. It's a relationship founded through trust and confidence from one party to another. When we talk about fiduciary relationship, when you're a fiduciary for somebody, you put that person on a stool and you're going to go out of your way to do even better for them than you would for yourself. You're taking care of everything for them in the highest manner, the best, fairest way possible. But you're putting their needs before yours. That's a fiduciary relationship. Take that very seriously in this industry. Agents may have authority to act on principal's behalf under one of the following methods. So we can have express authority. That's when we sign contracts. We have express authority to do this job. We have implied authority. We didn't really sign a contract, but you started taking me around in your car and you were doing this and doing that for me. Well, it's kind of implied that you're going to get something out of this by every party's actions. Apparent authority, and then we have ratification of getting that done. The equal dignity rule requires that the appointment of an agent for real estate contract must be in writing to be enforceable. In Ohio, absolutely. In Kentucky, as far as I know as well, it has to be, any real estate contract to act on behalf of somebody else has to be in writing. Why? Because real estate is one of the biggest investments we'll ever make. And we have a lot of consumerism out there to try to protect people from wrongdoing. So that's part of the reason this whole thing is in writing, a statute of frauds and everything else. We're putting all of this in writing. This is serious business.
If you're implying, that doesn't necessarily mean it's in writing.
No, but before you get to be paid, you better put something in writing. Otherwise, you won't get paid.
Yep.
Power of attorney. When the principal authorizes the agent in writing to act on his behalf. Power of attorney, a lot of us have this for our relatives that are becoming incapacitated one way or another. We have power of attorney for them. You might have it for your spouse if they go into medical emergency, where you have power of attorney to make some decisions for them. But this is where the principal authorizes the agent to actually act on their behalf, to negotiate on their behalf. As an agent, I'm never signing anything for my principal. I'm never signing. But I'm going to negotiate the heck out of it to get him the best deal I possibly can. Partially disclosed principals, a person whose existence is known to the third party but whose identity is not known. Okay, when I worked for McDonald's, we didn't go out to people and say, we're McDonald's and we're interested in buying your property. Because if we did, they saw all kinds of stupid dollar signs. And when McDonald's only made 2 cents on every burger they sold, we couldn't pay a lot of dollars for properties. We certainly couldn't compete with Walgreens and Rite Aid for that corner property. So we never told somebody we were McDonald's. We had agents going out there trying to buy the property for us, never disclosing we were McDonald's. But the agents out in the marketplace trying to buy the properties for us told the people they were trying to buy the properties from, not that we're working for McDonald's, but we are working for somebody else. We're buying the property for somebody else. But they wouldn't tell them who. So that's where this partially disclosed principal happens. An undisclosed principal is a third party is unaware of the existence or identity of the principal. The agents working for undisclosed principal is called a secret agent. We could have gone in this path too with McDonald's. Again, depending upon where the market is, maybe the secret agent is the thing we had to do to get a chance to even get the property. Mary Emery developed Marymount. How many of you are familiar with the town Marymount? Okay. In order to develop Marymount, she spent 9 years acquiring all the property. She had a plan. And nobody knew it was Mary Emery buying the property. She had people buying the property on her behalf. And then once she acquired all the property, she was able to designate different architects to design different parts of the village for her. If you ever get a chance to go drive through Marymount and see the old square where the apartments and everything are, you can see the style and you can see the fact that she used specific architects to build different parts of the village for her. It's a cool story, but she was operating totally in secret for all those years to get control of the land. Real estate brokers. The principal grants and defines the broker's power to act on behalf of the principal, typically through the listing agreement. Brokers are usually paid a commission on the property's selling price. So here's a hiccup. Okay, I'm paid a commission based on the selling price. To be paid a commission, it's my job as a broker to get the highest possible price I can get. It's counterintuitive to working for the buyer of property. Because your job as a buyer's agent is to give them the best property they can at the cheapest price you can get it for them, lowest possible price. But yet your incentive to be paid more to negotiate a higher price. So this is where you turn off some messages in your brain and you go just do the best you can for your client. And many years ago we didn't have something called dual agency. Everybody worked for the seller. And then people said, wait a minute. How can you work for the seller, be the seller's agent, and still represent me as a buyer? So, literally, in the late 80s, they came out with dual agency. And they decided to make it a law. We have forms now that say this is how it's going to work. And now agents can represent buyers. But up until that time, agents didn't represent buyers. They represented sellers. Now, in their mind, they were trying to do the activity of being a buyer, but we didn't have it in law. It wasn't part of the real estate process. So this happened, like I said, in the late 80s is when that actually started. Real estate salespersons, they're a state licensed special agent who assists broker in real estate transactions. So we can have special agents. In our market, if you get licensed, you can do anything. That's the whole idea. But if you work as an assistant, there are certain things you can do and you can't do if you're not licensed. They don't want assistants to attend open houses on their own. They can go to an open house. They can help run the open house, but they can't go to the open house all by themselves because they're not licensed. Because at the open house, they're supposed to be negotiating on behalf of the seller of the house. Now, why do realtors have open houses?
To attract traffic.
Yeah,
To attract traffic.
Property.
To get interest in the property. Okay, that's one thing, getting interest in property. Who are they attracting traffic for?
Well, a lot of the neighbors.
And for themselves as the listing agent. The idea behind having an open house is it's a way to get people that are looking for homes that you can go represent somewhere else. So the open house, yes, it's to show off the property and try to get people interested in buying. But ultimately, the bigger picture is to get activity for the realtor listing. So don't ever lose track of where this whole game is headed and what you're trying to do with it.
It just seems like there's usually just like pretty faces at the open houses. And they're not like the people who are on the little sign that's in the front. Like, I guess it's just...
They're part of the real estate team. They're part of the real estate team. Years ago, they used to send assistants in that weren't licensed. and they could get away with that. They can't anymore.
Okay, so all those people I've met at open houses are
Today, they should be licensed
they're
agents.
licensed agents.
Unless, okay, if they're just handing the cards out, they're just passing the tea out, and they're not being part of a negotiating conversation. Negotiations start happening, they step away. That tells you they're not licensed.
It just seems like more of a dog and pony show. It doesn't seem like there's real negotiation going on at open houses.
When I worked for the trust department, I knew that when I got a listing in Marymount that I could have an open house on Friday night and I'd have 3 offers on a Monday. Because I knew what I was dealing with in Marymount. But we typically used realtors to sell our houses because we didn't want to have to work evenings and weekends to do all kinds of stuff. But this is one where I told my boss, I said, I'll be able to sell this one right away because I knew what kind of market. And we did. We had 3 offers on Monday morning. Very competitive offers and vicious. But yeah, it just depends. You know, I had houses all over the city, and most of the time I let realtors sell them for me. When I was in the trust department, I could do that. If you work in Fifth Third's trust department, they expect you to, as the real estate manager, to sell the properties yourself. They don't part it out. So you used to be able to drive through Cincinnati and see houses for sale by Fifth Third. They weren't for sale by the bank. They were for sale by the trust department on behalf of their customers. And you'll still see that. Not much, but that's just because that department could make the realtor fee and keep it for them. Whereas Star Bank, where I worked, we let the realtors keep the fees. We didn't mind doing that. We weren't going to work 70, 80 hours a week trying to do this stuff. Real estate brokers, supervision and liability. The broker is required to supervise the salespeople that work for him and establish policies and procedures to manage and review their activities. That's part of this whole training process. When you're a broker and you take a licensed agent on, you say you're going to sponsor this person, you're going to help them get their license, and you're going to take care of them. You're responsible for training them. You have liability associated with that whole relationship. So this is a two-way street. When you guys are interviewing people to sponsor you, you want to find somebody that's going to do a good job by you, that's going to help you, mentor you, and get you through this and help you pass the test and help you find leads. But on the other hand, they also are looking at you saying, is this a liability? Is this somebody that I can train and I can work with that's not going to be liability to me? Brokers are liable as a matter of law for torts committed by their salespeople within the course and scope of their agency. So that's part of this wearing this broker hat. Everybody that's your agent is liability. They screw up, and they screw up on your behalf. So you're stuck with them. Listing agent, work with the seller of the property. Buyer's agents are brokers who enter an agreement with the buyer. A dual agent arises when a broker represents both buyer and seller in the transaction. When you have dual agents and you're representing the buyer and the seller in the transaction, at that point in time, you're no longer allowed to negotiate. All you're allowed to do is carry paperwork back and forth. You can coach people to try to keep the transaction alive, but you can't negotiate on their behalf. That's, as soon as you declare dual agent, that whole piece is taken away from you. It's to be fair. You're smiling because it doesn't really happen that way, does it?
I put an offer on a house on Rose Hill, and surprisingly, all of a sudden, 3 other offers. It had been sitting there for 6 months, nothing happened, and then all of a sudden, I put an offer on it. 2 others just magically popped up overnight, and then you're in a blind auction, and it's just
So you didn't buy it? You didn't get it?
I didn't know.
Which house was it? Here's the reason I'm asking. In my online class, somebody just did this, a house on Rose Hill. And I sold a house on Rose Hill from the trust department years ago. Rose Hill is this very unique little, cool little neighborhood. Wrong part of town.
Yep.
If it was in Hyde Park or Indian Hill, the houses would sell for millions of dollars. The house that my student posted was only $600,000, but I was so impressed with this cool, big, humongous English Tudor house. They had all kinds of built-in woodwork and stuff, curved archways, just coffered ceilings, just incredible place. But it's in Rose Hill. Rose Hill is just kind of like over in this part of town over here.
It's North Avenue.
It's North Avenue.
Yeah, that's
Yeah.
amazing.
Is that the one that I commented on?
Huh?
Is that the one that I commented on?
You probably did. Yeah.
Did I?
If you ever
I love
see
the
Belvedere.
like the built-in
Big Belvedere
Yeah, I
Hotel.
know, okay.
Yes.
I know what you're talking about,
North Avenue, right on.
yeah. There.
Well, it's
Mitchell-
off of
Mitchell-
Tennessee, it's by St. Bernard.
Well, I was saying the Belvedere Hotel is
Yeah.
kind of like the mark at the beginning of Rose Hill, where it's the
Okay.
corner of Mitchell and Raddick.
Yeah.
Yep.
But and I sold a house there for the trust department. I'd never been into that little, why would you drive in that neighborhood? You know, unless you had a reason to go there. But it's just a beautiful part of town. Really cool. Okay. Retaining the broker. Real estate brokers are retained through written contracts known as listing agreements. In many states, the statute of frauds requires the contract with the broker be in writing in order for the broker to be compensated. This is where my point was, is you can do implied contracts, but if you ever want to be paid, you're going to make sure that that's in writing, especially in Ohio. Types of listings. We have open listings. Allows the owner to retain more than one broker to sell the same property. First broker to procure the buyer earns the commission. How many of you are willing to take an open listing? Not too many people would be willing to do it. Unless it is a hell of a hot property and you have the buyer in your pocket. You have the buyer in your pocket, they've told you that they want to buy this property, the minute it comes up, you'll take that open listing. But at that point in time, you start to get into agency and everything else. I mean, there's a long path that's going to happen there. But an open listing means they're saying, hey, 10 realtors, you can put your signs on my property, tell everybody it's available. Whoever brings the first buyer in is going to get paid. Not the first offer, the first buyer. Because multiple offers can happen.
Who determines the commission on something like that?
It's going to still be the standard commission rate.
Okay.
And by the way, when I started this business, real estate commissions in Cincinnati were 7%. We were the highest in the country for real estate commissions. Cincinnati today, it's about 6%. It's still, that's on the high side.
I would say mine's 5, I think, with my agent.
And people are willing to do less because they think they can get more business. But the standard in Cincinnati was 7, and now it's been 6. And again, as realtors, we don't go to meetings and tell everybody, this is what we're going to do. We can't. That's monopoly kind of language. You're going to get in trouble for those discussions. But we do what we see going on in the marketplace, what's acceptable. And when we start doing 5 and 4, and Remax will do less. There's another, I can't think of the name of the company. They'll do less just because they start out that way. That's just us trying to undercut the marketplace. And there's a lot of realtors that will stare daggers at you for working for those firms because you're making all of our commissions less and less. In commercial real estate, the standard commission is 6%. Pretty standard. But in commercial real estate, it's 6% of $1 million, of $10 million. When we start going higher threshold, it drops too. There's a standard thing that says once it gets above a certain price, the commission rates drop. Commercial real estate agents can get 2% or even 1% when they go up to $10, $100 million. Hey, I'll take that 1%. But it does drop as the prices get higher. Exclusive agency provides that the broker's exclusive agent, the seller, is entitled to commission. Okay. Exclusive agency. This still means the seller can sell to their brother, their neighbor, or somebody else, and the agent won't get paid. This still lets the seller bring their own buyer in. The exclusive right to sell, the broker is granted exclusive right to sell the property, entitled to commission regardless of who finds the buyer. The exclusive right to sell is what most of us want to work with in our marketplace. There are people that if it's anything less than that, they won't even take the listing. It's not worth their time. Again, in this real estate world where we're paid commission only, and every minute we're doing something for somebody, we want to be realizing that we're going to be paid an end run there. We make our choices as to what we're willing to work on and not work on. Very much so. Multiple listing services, network of exclusive right to sell listings that provide listing brokers with a large market in which to advertise their listings. So when I started the business, there was only this thing called the MLS. And in order to work in the MLS, you had to belong to the Cincinnati Area Board of Realtors. Otherwise, you didn't get in, you didn't play. Because you paid dues, and you had to be a member, and only realtors got access to it. Today, we have something called Zillow. We have Realtor.com. Now, it still is not the same as the MLS. It still doesn't give you the instant information and the verified accuracy of the information. Zillow, I was playing around on it the other day and make me an offer. I went to go look at the house. I couldn't even see a picture of the house. I just know about where it's at. I thought, make me an offer. Hell, you didn't even advertise your house. But you need to understand when you're looking at these internet sites, who's really selling, who's doing what are they advertising. MLS, realtors know for sure that is a contract. It is a property that's ready to sell. It's been through the whole process. Whereas everything on the internet, you just don't know. Commercial property advertising frequently maintained by brokerage firms that specialize in buying and selling commercial properties. We have a couple of listings, CoStar and Exemptions, that are commercial type listing groups. As commercial agents, we pay a fee to use their services, to be able to search their records and do things. We pay fees. It's a per agent, per license type fee. So there is CoStar, there is Exemptions. We do have a commercial type listing system. It does. I mean, in today's world of internet, you got to have something to get out there and see it. The broker, often paid via two methods, a commission or a net listing. In Ohio, we're not allowed to do net listings. In Ohio, it's commission only. We don't do net listings. Net listing means I'm going to sell you the house and I'm going to make sure you net this price. Ohio doesn't let realtors operate that way. Commissions are the most common means by which a broker is compensated. You can get paid hourly. You can get paid a lot of different ways. Hey, it's as creative as you want to be, but not a net listing. Ohio has laws against that. Brokers are entitled to compensation when a broker represents a ready, willing, and able prospect to the listing seller under the terms and at the price stated in the listing agreement. Okay, so ready, willing, able buyer, met the terms, fully did the contract, they negotiated, they got to where they should be, everybody signed the contract. There's still contingencies in that contract. We have financing, we have homeowner inspection, we have all those kind of contingencies. Once we get through those hurdles, we have a ready, willing, able buyer. At that point in time, you've pretty much earned your commission, unless the buyer backs out. If the buyer backs out, the seller is going to keep the earnest money. If the sale doesn't happen, how are you going to collect anything? If the seller backs out, you can go back to the seller for damages.
So,
That's part of your exclusive listing agreement. You'll have provisions in there how you're going to get paid. It's not a suit, it's a contract. But yes, ultimately you may have to go after them in court to get paid. Yeah, it's a vicious business. The procuring cause. This is the cause, the broker who through his or her efforts laid the foundation for negotiations that resulted in the sale. Again, I compare this to my threshold theory. Person that brought somebody over the threshold is the person that saw them into the transaction, gets to earn the commission. Today, a procuring cause means all you have to do is plant the seed. Give them the lead. Show them something that house was available for sale. Start that process. But you can't just start it and step away and expect the sale to happen and get paid. It's not going to happen. But when you start that process, you keep working with them through the whole process. Sit down with them when they're writing the contract. You are the procuring cause. You've proved it. But don't just say, I planted a seed and I'm done my job. No. Stay with them through the process. And this is, again, the procuring cause is where realtor to realtors have fights about the ethics and about who was procuring cause. They take those arguments to the Board of Realtors, to the committee of the Board of Realtors to help decide. A net listing, the broker must sell the property above net price to receive any commission. Again, we don't do this in Ohio. Expired listing commissions protect the broker from sales occurring after the expiration of the listing term. So I've had the listing, whether this is commercial or residential property, I've had the listing for the last 180 days. The listing's done. I'm going to give a list to the seller that says, these are all the people I brought through the property. These are all my people for the next 6 months. If any of these people buy the house, I'm getting paid. They rent the office, I'm getting paid. They buy your building, I'm getting paid. This is standard practice in everything we do. That whole time we were doing the listing, we generated a lot of leads. And if they didn't close during that listing period, we have a protection period that goes beyond. Because we brought them into the transaction, we expect to get paid.
What if someone who's on that list then like rehired another buying agent? Would both of these agents?
We'd probably go to the board of realtors, have a discussion. And that's one of the things you need to make clear when you put this list forward. Everybody that you put on the list, you need to communicate with them. That, hey, you're on my list. I expect that if you buy the house, something happens, you'll honor me. I put you on a list. We have that conversation. We let them know. It doesn't mean it's guaranteed, but we have that conversation. Real estate licensing. Licenses are required to meet certain levels of competency, ethics, moral character to become real estate agents and must continue their education to maintain a license. So part of your license exam, what you're going to turn in, when the broker sponsors you, he says he knows who you are. He may have only met you and just talked to you very briefly, but he knows who you are. He has some degree of understanding that you're an ethical person, that you have moral character. They think you would be a good realtor. That's what they're signing a paper to sponsor you that says that. They generally require the following to obtain a real estate broker's license: minimum age, residency, moral character, examination, professional experience, educational experience, fingerprints, and convictions. Now, this second stage that I just talked about was a broker's license, not a sales license. When I say broker's license, this little thing down number 5 called professional experience. In order to get a sales license, you have no professional experience. You've taken the classes, you sat for, you passed the exam. That's it. To get a broker's license, you have to have so many real estate classes, and you have to have a minimum of 25 transactions. That's sale transactions. If you're an office person, the way I got my broker's license, at the time I had to have 75 lease transactions. Because at that time it was 25 transactions required. Now it's 20, I think it would be 60. But you have to have that many transactions. They want you to be experienced. Now, the broker's license as well as the real estate license exams are both residential. If you're doing commercial work in our market, you still got to know residential to pass the exam, because the exam is totally residential. So all of my experience up to that point had been commercial. I had to go take the crash course to take a broker's exam. I had never seen a closing statement, because that's part of your test. I hadn't been selling houses. I'd been doing commercial leasing. I managed an office building. So I had to go learn commercial to be able to take the test. Last year when I took the Kentucky broker's test, I had to go learn Kentucky residential real estate to pass the Kentucky broker's test. Because they unfortunately, and it's what it is, all the tests are based on residential. They're not based on commercial. So if you want to be a commercial agent, there's no test. There's no level that says that you're residential versus commercial, other than the experience that you get doing it. So those of you that are interested in commercial, it doesn't make it any more or less easier. It's more difficult to get into. But just because you're an agent, you can be commercial or residential. We like to call commercial agents brokers, but there's only a handful of commercial agents that are brokers. Most of them are just agents, because they've never sat through all the course requirements. They've never taken the broker's exam. Most of them don't want to learn residential. Most of the commercial agents, if it comes to selling their house, yeah, they'll sell their own, but a lot of times they won't work for anybody else in residential. They won't help a friend buy a house. They'll say, please use a residential agent. They don't want anything to do with it. Licensing. Exemptions from licensing requirements. State laws permit individuals to engage in certain real estate activities without the real estate license. This is where we talk about real estate assistants. What can assistants do in our offices to help us? And assistants are usually paid salary or an hourly wage to help us out. They'll put stamps on marketing material. They'll help us do our Facebook page. They'll do mailings. They'll help get an open house set up. They may go work at an open house, but they can't be there by themselves. It still has to have a licensed agent at an open house. That changed. Unlicensed activities. Acting without a real estate license when one is required is illegal and may subject to personal criminal penalties. Will, if they catch you. Finders. An intermediary who brings together parties for a business opportunity or real estate transaction. Ohio has laws about paying finder fees. We don't allow it. We only allow commissions to be paid. So if somebody thinks they're going to get in this business and make money by bringing buyers and sellers together and they're not licensed, you're doing something illegal already. We don't allow the finder fees. Brokers' duties to principals. Again, this fiduciary duty. Do the act in the principal's best interest and not advance their own. It's called COLDAC, Care, Loyalty, Obedience, and Accounting. There's ways to remember this. When you take the Principles and Practices class, you'll see the words to help you remember the care, loyalty, obedience, and accounting. Those are our responsibilities. And you'll be tested on those. Third parties. Brokers don't owe any duties to third parties, but we are going to be honest. We will tell a third party, I don't represent you, I can't give you that information. I'm representing somebody else in this transaction. We can answer yes/no questions to an extent. We can't do misrepresentation. Arises when a broker either intentionally or negligently misrepresents the material fact to the third party. Boy, oh boy. You negligent misrepresent a material fact, you will be sued. You will be part of that lawsuit. That's part of this whole property disclosure piece. Even though the seller is responsible for filling that form out, you're the agent, you're involved in the sale of that. If there are hidden defects and you didn't go through that with your seller and you didn't make them disclose that and you were totally ignorant about it, you'll still get sued. So when your sellers fill out their property disclosure form, that's their homework. They're supposed to fill it out. You're an agent, you sit down with them and go through it thoroughly. You ask them all kinds of questions after they fill it out to make sure you're not going to get sued. Please show me what you did. When you did that little bit of remodeling, show me exactly what you did. Did you go behind the wall? Did you have electric done? Did you do some plumbing work? I want to see what you really did. I want to know more about it because I want to know if it's properly disclosed in this form. When you put a new roof on the house, did you really tear off the roof or did you just put another layer of shingles on? What did you really do? Ask those questions. Intentional non-disclosure. This is called deceit. A broker remains silent when having a duty to disclose the known material facts. You'll see all kinds of ethical case studies of this stuff, where somebody comes in, they're not familiar with the neighborhood. The basement floods when it rains really heavy, but otherwise it's not flooding. And somebody might ask a question. They're on a relatively dry day, and it's been months since the basement flooded. It doesn't smell real bad. People are good about cleaning up, but they might ask a question about it flooding. And you, the broker, know that, or the agent, you know that because you've lived in that market for a while. You know that area floods. You know what goes on. But you let that buyer or that seller tell the buyer, oh, no, we've never had a problem here. And you're there watching it all go on, and you don't make a correction. That's deceit. That's non-disclosure. So you be very careful. Again, this is making sure the property disclosure form is filled out right, so you never have a non-disclosure issue. And what you want to do is you tell your sellers, no matter what happens, you're their agent, you're going to represent them, you're trying to do your best to sell the house for them, but you will not participate in things that are going to make you in trouble. And you have those conversations up front. These are kinds of things that are going to get me in trouble. Non-disclosure, deceit, fair housing. I'm sorry, you have your certain opinions about how things are done. I'm guided by fair housing laws. This is the only way I'm going to sell this house. You may have your own reasons, and if you've got your own reasons and you do what you want to do, then I don't want to be part of your transaction. That's the other thing you have the ability to do. You don't have to take a listing. You're paid on commission only when the thing sells. If you're not comfortable with the things your seller is telling you to do, don't take the listing. Listen to your gut feeling. Mandatory disclosures required by states. Many states require various disclosures made to buyers. Association assessments, death. Okay, in Ohio, we don't tell everybody up front, so-and-so died in this house. But if they're asked, if somebody asks you, did somebody die in the house, you should be able to say yes or no. Don't have to go into details, but you do say yes or no. And I'll tell you, if a house has been around long enough, somebody probably did die in it. You don't know the history of the house, but somebody probably did die in it. Again, it's when certain people have weird feelings about a house. And they're not going to buy a house if they have a weird feeling. They'll ask about those things. Hazard disclosure, insulation, relationship and duties of the parties to transactions, special tax district, toxic mold. Again, things that you need to know about. Selling property as is. Sellers offering the property in its current condition without agreeing to correct any known defects to the property. I did this when I was in the trust department and I sold estate houses. We didn't fix anything. Why? Because there's implied warranty. If we as the bank, as the executive of the estate, made repairs, sold the house, and the repairs were defective 6 months to a year from now, they were going to come back and sue us. Because we hired the contractor. So what we did is we worked with people. You're taking the property in its as-is condition. What we did is we negotiated price with them. This needs to be repaired, fine. Go get a bid. I go get a bid, they go get a bid. We come up to a price and say, okay, we agree to give you this money off. It was better to do that than take the liability of doing the repairs. Brokers still have a duty to disclose patent defects to potential buyers. And again, you tell your sellers, if you know about these defects, it's your job to disclose them. It's better if the sellers disclose them themselves. Client to broker. Principal's duties of real estate broker often include the duty to compensate, to reimburse, and to indemnify. This is to the broker. The agent is paid by the listing broker. Both agents, actually. In today's markets, the only person that gets the paycheck is the listing broker. You're representing the buyer, you're going to get your check from the listing broker. You don't get it at the closing. You get your check a few days later from the listing broker. That's the only party that will get paid in the transaction. But the listing broker is entitled to be compensated. They're entitled to be reimbursed if they have to have extraordinary expenses, and they're indemnified in the process. The seller's indemnifying them, protecting them, their liability. You can still get sued for anything. Principals are to act in good faith toward their brokers. So we expect the people that are clients to act in good faith to us. Be right by us. Disciplinary matters and recovery funds. We actually have something called a recovery fund, where if you're found guilty of infringements, you've done something wrong in the real estate world, the Ohio Division of Real Estate will cite you, they can fine you, they can make you pay into this fund. And this fund is a recovery fund that's used to pay people back when they've been wronged. So license suspension or revocation can happen for breach of fiduciary duty, for discriminatory practices. So not only is fair housing wrong, but you can lose your license. Failing to comply with contagion requirements. Boy, this happened to me one time. Our broker didn't do contagion requirements. They pulled all of our license. They pulled his and pulled all of ours. So he had to come back and get somebody to step in and be able to reactivate and pay fees to reactivate all of our licenses. This is back when I managed the building downtown. It was a New York broker. He didn't have to take an education in New York, but he had to take an education in Ohio. He was older. He's like, I'm not going to do that. So they jerked our licenses away. So he went to West Virginia and he transferred his license back through reciprocity. Then we all got our licenses back. A few years later, did the same thing. Then they didn't accept West Virginia's reciprocity. Then we were stuck. That's when they came back to me and said, Joyce, you're a broker. We're going to use your broker's license. I said, okay, fine. I won $8,000. What do you mean? I said, I won $8,000. Well, I worked for you. I went back to school to get my bachelor's degree. Y'all didn't pay for any of that. I paid for my real estate licensing classes. You didn't pay for any of that. I paid for this, paid for that. I gave them a bill for $8,000. They gave me walking papers. That's when I lost my job. You never know when's the right time with the hands up. But I really felt strongly about getting paid for that. They had already filed bankruptcy on the property. It was just a matter of time. The felony conviction. If you're convicted of a felony while you have a broker's license, they can pull your license. Any license at all, pull it. Misappropriating of funds, misleading advertising, and unauthorized practice of law. We're not allowed to be lawyers. We're not allowed to draft language. All we can do is do check boxes and write words on these prepared documents. We can't draft language. If there's more language that has to be drafted, we tell our clients to go seek the help of an attorney. And we'll have attorneys in our we have little books with all kinds of people who can help you get your house sold. We have our little referral books, little black books that we keep, and we have a lot of good contacts to help us keep our business going. We'll tell them to contact an attorney. I do law and stuff every day when I'm negotiating contracts for our service work, but I'm trying to find contracts that we've already done. I try not to be I let the operations manager or the asset manager be creative and let them write the language. And I never sign the contracts. I just pass things around. Damages against a broker. If a broker breaches the contract with a principal, the broker is liable under contract law for resulting damages. Other remedies may allow an injured party to sue a broker. Okay, so these are things where we're allowed to get sued. We can get sued all the time, but we're allowed to get sued when we breach fiduciary duty, recovery of secret profits earned by a broker, for recovery of broker's commission, and for punitive damages. We're allowed to get sued. Punitive damages. They took us to court. They got the damages. Punitive damages goes beyond. That's the penalty phase. Federal laws regulate brokers. Housing discrimination. We all have to work under Fair Housing Act and the Civil Rights Acts of 1964 is amended. They've been amended in 78. They've been amended a few times. And they will continue to be amended. We're going to continue to see more protected classes of people. That's just where our world is going. We can't do racial steering, which is a prohibited form of housing discrimination. We can't do blockbusting. Homeowners are told to sell their homes because people of a particular race, religion, or national origin are moving into the area, and housing prices will likely decline because of their presence. Guess what? What neighborhood were you guys talking about before? Avondale? North Avondale? Back in the 60s, this was going on all the time. Blockbusting, all kinds of stuff was going on to change those neighborhoods dramatically. U.S. Patriot Act requires establishing minimum standards for financial institutions to verify the identity of a customer. I do something with all of my vendors and my tenants. I actually have them reviewed periodically to make sure that we, as a company, are contracting with people that follow U.S. Patriot Act guidelines. I hire a company to go do background investigations. I turn a form in every quarter with a list of my changes of my tenants or my vendors, because we're always looking for you. That's what we have to do for our client. That's part of our management agreement that says we got to do the OFAC check. So OFAC is U.S. Patriot Act. And that is it. 10 till 8, and I finished up. Any questions? Okay, give me a minute, and I'll just check out some homework real quick, and I'll hand you homework back tonight.